Good morning. I'm Diane Cohen with MacroPro, and I'm joined by Wendy Stevens. Hi, Wendy. How are you?
I'm doing well, Diane. How are you today?
I am fantastic. We just had our company Christmas party. We did a really fun casino night this weekend, so it was very fun. But, kind of puts me a little behind on other things I need to get done.
Oh, are you ready for Christmas? Are you wrapped and
I'm
gifted
getting there.
all together?
No, but you see, by my decorations behind me, I do have most of my decorations up.
Oh, that's wonderful. That's absolutely wonderful. Well, my packages are not wrapped and I am not ready, but let us know in the question comment box if you are all ready for Christmas, if your gifts are wrapped, or if you're getting packed up to head out of town to see family and friends, or even going on a fun ski trip or something.
Oh, that would be great. I'd love to see what people are doing and if they're ready for Christmas. So I'm going to do a little bit business before you introduce our speakers. So our speakers, just as a reminder for today is part of the 12 CEUs of Christmas, and we're delighted to bring this programming to you. Each webinar is worth 1 CEU. You must log on to the GoToWebinar platform with your own link, because that's where the name is going to show up. It's on the registration. Whoever registered for it is going to get the certificate. If you call in, unfortunately, there's no way they can record your time and attendance. So you will not be able to get credit unless you are in with the link. And then if you would like the handouts from today, because there could be they're great handouts. They've got a lot of information in it. You can download those. And then if you have any questions, put that in the question box, and Tom's going to be asking those questions a little bit later as they go along. And then you can watch this on YouTube as a encore performance. So I think that's about everything. Wendy, did I miss anything? Anything else we should say?
I don't think so. We know that you're going to enjoy the presentation today.
Absolutely. All right. Well, Wendy, take it away.
Thank you so much, Diane. I am very excited to introduce some good friends. We have Adabela Bonillo and we have Tom Wishart of RTGR. We're excited to have them. I think they're here. Adabela, Tom, are you here?
I'm here.
Oh.
Hello.
We're out Christmas shopping, getting their final Christmas shopping done. We're excited to have them join us today, and we're excited to hear what they have to say about indemnities and some of the joyous things that goes into taking care of all of that. So Adabela and Tom, thank you so much for joining us, and we shall see you on the other side.
Thank you, Wendy.
Thank you, Wendy.
Hi, Adabela.
Hi, Tom.
So Adabela, you're going to do the slides, right?
I am.
Okay, there you go. You just proved it. So let me introduce you before you get started. First of all, I want to welcome everyone and thank you for joining us. Today we're going to talk about exciting Christmas topic, which is workers' compensation indemnity claims. We're going to cover today the best practices some of the best practices for covering dealing with workers' compensation claims that involve indemnity, from the start of the claim all the way through the end of the claim. That includes delay and denial of claims and benefits, including TD, temporary disability benefits and how they're calculated, what is the benefit, notices, common issues that come up with temporary disability payments, like the amount, weekly amount that's due, return to work issues, seasonal workers, and then retirements and terminations of employees and how that affects temporary disability entitlement. And then we'll wrap up with questions. But if you have questions before we get to the end, you can put them in your little question box there on your screen. Where's my finger? There it is. Somewhere on your screen it'll pop up. And if you put your questions in, I'll be monitoring them while Adabela does most of the talking. And if it seems like something that we should talk about before we move to the next topic or before we get to the very end, I'll kindly interrupt, and we'll try to take those while we're going. So first, a disclaimer. Well, first questions. This is questions. Our firm, RTGR Law, has offices all across the great state of California, including very recently we added on this list, Salinas is now, we have now an office in Salinas. So if you have questions about this topic, obviously you can email Adabela or me, or ask them during today's presentation. We're happy to do that. But if you have questions that are more specific to your region, or if you want to ask something not related to this particular topic, but regarding workers' comp in general, you can email your closest RTGR Law office, and that'll go straight to the most senior partner or senior attorney in that office, who will then be happy to help you out. Okay, now we'll disclaim the fact that this is an informational session. We're talking about a whole bunch of stuff in a pretty short period of time. It's not intended to be a replacement for legal advice, but is for general and educational purposes only. And down at the bottom there is another link you can use to contact us. And if you don't keep track of all those office emails, you can always reach us through our contact page on our website. Okay, before we get started, let me introduce you to Adabela, who we were so excited at RTGR Law in 2024, because the best thing that happened to the law firm the whole year was that Adabela became a partner in the firm. Woohoo! And so we're happy to call her a partner, and it's very well deserved. So she now is officially a partner. That means she knows what she's talking about. And in addition to being a stellar partner at RTGR Law, Adabela is also the president of DVICA, the Diablo Valley Industrial Claims Association, where she does all kinds of miraculous things. So she's a pretty important person and very knowledgeable on this topic, among others. So without further ado, I'll turn it over to Adabela.
Thank you, Tom. Well, now I'm blushing, because to hear all those lovely things from an icon like Tom Richard means a lot. Thank you all for joining us here today. I'm sure everyone's excited on this Monday morning to talk about the amazing topic of indemnity. Even though this is something that I think all of us deal with on a daily basis, there are a couple of nuances that we've seen come up at the board and on DORs and such, which is the inspiration for this topic. But before we get into that specifically, the issues with indemnity start at the beginning of the claim. So we're just going to go over some background information. I'm sure you're familiar with it, but just to serve as a reminder before we get into those little crevices of indemnity issues that we see at the board. All right, so first and foremost are the legal obligations of California employers for the claim processing. So if there's an employee injury, the employer should, within 24 hours of learning from the injury, provide the injured employee with a DWC-1 claim form. Even if the injury seems suspicious, that's obviously something that they should tell their insurance or their TPA about, but regardless, that form should be given. We actually do presentations for employers as well, as sometimes there seems to be some questions about what exactly knowing about an injury will entail. That's a whole other area we can get into, but when push comes to shove, if there's a doubt, just give the claim form. And in order to begin the claim, the injured worker must have the claim form delivered personally to the employer or send it by first class or certified mail. Any written proof that the claim form was provided and not returned is obviously what we love to see from a legal standpoint. Now, after the employee returns the claim form, the employer must direct the employee to industrial medical clinic or provider. Medical treatment should be provided unless the claim is denied. There might be an instance where the claim is denied within 24 hours, but usually you would expect there to be at least a little bit of a period there where they could get some treatment. Medical treatment shall continue until the date that liability is accepted or rejected. Now, during the delay period is a fun little time where they can actually get medical treatment up to $10,000. That's a great strategy too for insurance companies or employers, because we also keep control of the medical treatment during that period. And all that medical treatment can be used as part of the investigation to deny the claim in good faith, being able to say that you tried to figure out what was going on, at least medically, and based on those medicals, you've made a decision. So again, unless it's completely obvious that it should be accepted, I always recommend a delay first so that if it does get denied, you can argue that it was in good faith. All right, managing the delay period. So let's say that you do decide to delay because it's not completely obvious from the beginning that this should be an accepted claim. The notice of delay should be sent out to say that they're conducting an investigation before accepting or denying the claim. It's really important that these notices go out because should this case become litigated, the more correspondence that is given to the applicant or the applicant's attorney, the better. It will never be used against the defendant if you're constantly updating them about what's going on in the claim. The same cannot be said if those notices are missing. So the delay usually I've seen go out, but every once in a while it's not going out immediately. And so there might be a questionable period where the applicant's saying, I don't know what was happening. Applicant's attorney later said, we don't know what was happening. So please, send out that notice of delay. During this delay period, we have medical control up to $10,000 for medical care, but the employer is not required to pay TD for wage loss during the delay period. So that's a nice little thing to note. And if the claim is put on delayed, the employer has 90 days from the date of injury to determine whether to accept or reject the claim. Otherwise, it is presumed accepted and all the benefits must be paid.
Adabela, I just want to point out, if you can go back one slide,
Sure.
that for those of you who have safety officer claims, those working with public agency clients, there's only 75 days to accept or deny a claim. If it is a presumed compensable claim, such as cancer, heart trouble, Lyme disease, any of these PTSD, any of these body parts that are subject to the safety officer presumptions, then they've limited that time to only 75 days. So just keep that in mind too, please. But generally everything else, vast majority of workers' comp claims, it is 90 days.
That's true. Yeah, there's a whole other avenue if we're going to get into safety officer claims. So thank you, Tom, because that is true. So now just temporary disability. All right, so just as a reminder, temporary disability, what it is wage replacement, which is obviously different from what permanent disability is. Even though they kind of sound the same, they are different. So when the board is looking at when temporary disability is owed, the question is, would the employee be due wages at this time but for this injury? So employees who are temporarily unable to work at their jobs during the period of medical recovery are entitled to temporary disability because it's a replacement to lost wages. Generally, these benefits are available until either the employee becomes permanent and stationary, returns to work, or was deemed able to return to work, or for 104 weeks of temporary disability has lapsed. Again, going into the safety officer claims, in that case, they'd be entitled to 1 year of 4150 or full wages. And then for the second year, that would be when the TD payments would come up. So really quick, the difference between temporary total disability and temporary partial disability. If you get a report that says the applicant is TTD, then what that essentially says is the injury is so severe that the employee is unable to return to work for whatever time the doctor designates following the injury. Obviously, this has to be recertified every 45 days. It is calculated by taking 2/3 of the injured worker's average weekly wage. And we'll go into that about how to calculate average weekly wage shortly. And there is also a minimum and maximum rate set every year by the California legislator. One quick side note on that. I hate when doctors just say the applicant is totally TTD unless it's immediately following a surgery. I always try to get them to push for at least some restrictions to see if they could be accommodated. Obviously, some employers are more able to accommodate than others, but that accommodation can make a very big change when it comes to overall exposure of the claim. Again, because even if the applicant can only partially be accommodated, that could lead to them only being eligible for temporary partial disability, which is that if an injury limits the employee to fewer hours of employment or to a lower paying position. If the employee refuses this work, he or she may not be eligible for temporary disability payments at all. And the amount that is how you calculate temporary partial disability, and we'll go into the actual accounting later, but in short, it's that the amount is the difference between the average weekly earnings and the weekly amount in which the injured worker will probably be able to earn during the disability. And that's set by Labor Code 4657. So let's just go over real quick what we just established. When in the claim is temporary disability due? One, when the claim is accepted, not when the claim is on delay, or obviously if the claim is denied. It is due when medical evidence supports that the injured worker has to be off work. It's also due when the employer cannot accommodate work restrictions. It can also be due retroactively, like for example, when the claim was originally denied, but then later accepted. If the PPP said that the applicant could work, but the applicant hadn't returned to work, and now all of a sudden a PQME or AME say retroactively the applicant was actually supposed to be off work. And in these two situations, make sure to check with EDD before you issue a retroactive payment. The best way to handle that situation is to send a notice of temporary disability delay and explain why it hasn't been issued immediately. That will keep an applicant's attorney from filing for an expedited hearing, or even if they do, it's a defense against any interest or penalties. And like I mentioned earlier, public safety officers are entitled to 1 full year of salary per Labor Code 4850. So in summary, when is in the claim is a temporary disability not due? As we've mentioned, when the claim is denied, if there is no medical certifications of temporary disability, once 104 weeks have already been paid, after 5 years of the date from the date of injury, that's per the Labor Code, when the applicant is working full duty, or when the applicant has reached permanent and stationary status. Kind of already started touching on this because of, as it says here, how important the notices are. But here are some of the notices that we love to see when a file comes to us for litigation. The first is acceptance and denial notices. Per Labor Code 5401, within 1 working day of receiving the notice, knowledge of injury, which results in lost time or medical treatment, the employer should provide the claim form and notice of potential eligibility for benefits to the applicant. Now, if the claim administrator denies the claim, then the employee should be noticed of that denial and why it was denied. And the notice should be sent no later than 14 days after the determination of the denial was made. And when there is some strategy to determining what should be in a denial notice, some people will just put everything that applies. I think there's definitely a strategy to that as well. With that said, once you make those an issue, then it's going to be harder to go to trial until all those issues are investigated. For example, let's say that it's denied both based off of a lack of med legal evidence and based on a factual or legal denial. The factual or legal denial might be ready to go forward to trial sooner than the med legal issue. If all of those issues are on the notice, then a judge is less likely to set it for trial just based on the first 2 issues, since technically the denial is reliant on the med legal as well. So if you have a very strong factual or legal denial, you might just want to list those. But then you have to be ready to go forward to trial as soon as those investigations are done. And you definitely want to have proof as to what type of investigations are being done in anticipation of that issue going to trial. Lately, it has been very hard to set a case for trial on AOE COE, even if it's based purely on a legal or factual denial, because judges just want to have the case completed with all issues, including med legal. But again, there are arguments to be said as to why it should go forward. The most common issue I've raised lately with the rise of multiple specialties is that we won't be able to get a final med legal determination until we have, 3 or 5 separate specialties evaluate the applicant. And for an economical standpoint, it really makes sense to go forward on AOE COE based on the factual or legal before having to undergo all of those costs and also that time for the applicant. Notice of starting temporary disability. It is required the first time that the applicant is being paid this temporary disability that they get the notice. We also recommend that anytime there is a change in temporary disability status, that you send out another notice. Again, sending more notices than are needed is better than sending less if this case were to get litigated. So for example, if there was an offer of modified work, if the applicant returned back to work, if there is a delay period because the applicant stopped seeing a doctor regularly, I'd love to see a notice of intent to terminate the temporary disability or notice of termination because of return back to work offer, etc. Another notice that we like to see is a notice of change of benefit rate. And this applies to both TD and PD. The claims administrator shall advise the employee of the amount of the new benefit and the reason for the change. So if there's a change for whatever reason, for example, you found out that the applicant actually had concurrent employment for which this injury is also taking them off work. So now you have to incorporate maybe more money into the TD. Or what I've also seen, that the applicant actually had concurrent employment that we didn't know about, and they're still working that, and now they're working that job more. So we deserve a credit to the TD that's being paid. That's also a moment where we want to inform the applicant or the injured worker what we're doing and why. And if there's ever a doubt, if all of a sudden you think, oh, wait, maybe the applicant did get another job, or maybe the applicant is on EDD, or something weird's going on, send a delay.
Hi.
Go ahead.
Yeah, may I just jump in real quick too? There's a question that was asked that I think is kind of
Sure.
split to this topic of dual employment, which is how do you calculate TD when the injury occurred at one job, let's say the job you're on, but the person is working 2 jobs, what was working 2 jobs, how do you calculate TD at that point?
Sure. And the question, so what you're going to want to take is, okay, what is that? You're going to calculate average weekly wage with both salaries. The big question is going to be, is the applicant able to continue working that second job, or have they been taken off work with that job as well? In order to come to that decision, a deposition of the applicant is useful. Subpoenaing the employer records from the secondary employer to see, one, how much they were actually getting paid, whether it was regular employment or just kind of sporadic, the job duties, so that you can confirm whether or not fully TTD applies to that. And so if they are off work for both employers because of your injury, you will have to take that into consideration when calculating a WW, or average weekly wage, and we'll actually go into those calculations shortly. If they're still working that other job, then I would say that then it becomes a temporary partial disability situation if you want to do it correctly. I've also seen it where that second job was just ignored if it's unaffected. I think down the line that could cause issues, like, for example, if the applicant goes out because of a surgery, etc. So I think the best course of practice is to incorporate any income that you know, and then if necessary, create a wage loss payment rather than a full TTD payment.
Great, thank you.
Yeah. So, sorry, Tom, I lost my spot. No, I'm just kidding. That is a great question, and it comes up a lot. And again, I don't think ignoring that secondary employment is useful because one, you might want to join that employer down the line if it somehow becomes a CT, or perhaps create a new CT, et cetera. So I think acknowledging that when calculating is important. So again, if an applicant's entitlement to temporary disability cannot be determined, a notice of delay must be sent within 14 days after the date of knowledge of injury and disability. And if the determination can still not be made, for example, you've subpoenaed the concurrent employer's records, you still haven't gotten it within 14 days, then you want to send an additional delay notice. You want to track all of the efforts that you're making as well to show that it is being delayed or denied in good faith. So what is missing? Is it a medical certification? Is the applicant working somewhere else? Are you waiting on EDD? Are you waiting on subpoenaed records? Whatever it may be, it's always great to mention that. And then once received, update that delay notice or acceptance notice or whatever type of notice needs to go out based on the evidence that you have received. So if you are denying temporary disability, a denial notice must be sent within 14 days after the determination to denied was made. If the determination was based on a medical report, the medical report must be attached. If, let's say, you're not getting any medical records, then you want to send a notice of intent to terminate before issuing the denial. That gives them the opportunity to try to remedy this issue before they are cut off. And we'll get really into that in a little bit. And then you also want a notice of benefits ending, which should be sent at the time of the last payment. And it should say why. So was the applicant released back to work full duty? Is there a permanent and stationary report? Is the applicant not complying with medical treatment and so you don't have a medical certification? Whatever it may be, that's what you want to include in that notice. And remember, once an applicant is permanent and stationary, temporary disability is not due. If the applicant is not back to work or making at least 85% of the salary before injury, then the PDAs or permanent disability advances should begin. The California Supreme Court did hold that an employee who has become permanent and stationary following an industrial injury and return to work is not entitled to temporary disability, even if they are continuing to pursue treatment. And so an employer is allowed to tell an employee to use sick time or vacation leave. But to note that an employee is not permanent and stationary until the entire disability is permanent. So if they're permanent and stationary for, let's say, 3 of the 4 body parts, but that darn neck just isn't permanent and stationary just yet, they are not considered permanent and stationary, and they are still entitled to temporary disability payments. The true date of permanent and stationary is when the last body part becomes permanent and stationary. All right, now that we have a couple of, we've covered some of the background, if there's no other questions, we'll go into what we've been seeing at RTGR come up as little litigious issues that applicants' attorneys have caught on to and that we see ourselves litigating. Are there any questions, Tom?
Hi, I muted.
All right.
No, there's no other questions.
Great, okay. So here are some issues that we've seen. One, the applicant's not receiving regular or timely care. There was a return to work, temporary partial disability in calculating average weekly wage, seasonal workers, credit for temporary disability overpayments, and retirement and termination. So if there's a delay in medical treatment, or what I see a lot in diagnostic testing that is caused by the defendant, temporary disability will continue during the period of delay. So if you see you are denying MRIs, X-rays, diagnostic testing that either the PTP, med legal evaluator, or both are requesting, this could be creating a delay that's actually going to result in paying more TD. So I always recommend that non-invasive diagnostics be authorized as soon as possible so that whatever delay occurs cannot be blamed on the defendant. Now, if the applicant won't attend the appointments or won't set up the appointments with the help of a medical access assistant, then we're able to shift that back and potentially delay or deny ongoing temporary disability, but that delay cannot come from us. So the courts have found that reasonable delays by an applicant will allow for the continuance of temporary disability, but it has to be reasonable. And so if you just have an applicant that is not responding and all of that is being, that you have written proof of that from your vendor that's trying to set that up, that's a different situation. But let's say the applicant is sick or just can't appear, within the next week, but it can be there the following 2 weeks, it's not a slam dunk. So do keep that in mind. In order to pressure the applicant to do things faster, though, you can send a notice of intent to terminate temporary disability. That normally lights a fire under them. But you should continue temporary disability for a good faith period. And that good faith period will be determined by the facts of the case. Have they been lagging the entire time? Is this the first time that they haven't missed an appointment? All of those little factual nuances will matter. Please, please, please just keep a written diary of everything that's happening. Make sure that you're contacting the applicant or your vendor's contacting the applicant or the applicant's attorney consistently. And then that way you're able to defend that ultimate denial of temporary disability should the applicant still not comply. So an employer's liability for temporary disability terminates when the applicant is deemed able to return to work. This is true even if the employee doesn't return back to work. Refusal to work means no temporary disability. There are a couple of caveats, though, before we can say that the employee truly rejected a work offer. First, the employer must make a bona fide, valid proposal in order to avoid liability. This offer does not have to be from the original employer. It could be from another employer, and self-employment also counts. If you are the original employer, you want to make sure that it's a job that fits within their overall general prior employment contract. Like, for example, if the applicant used to work 8 to 5 p.m. every single day, pretty standard, and now you're switching them all of a sudden to night shifts on the weekends, that might not be considered a bona fide offer because we knew that the applicant was set up to work during the day. So you want to make sure that it's something that makes sense for how the applicant had been working before. And let's say that they are offered a job, the applicant accepts the job, but the applicant is making less money in this new job. Applicant may be entitled to temporary partial disability, which is also known as wage loss. Wage loss seems maybe simpler than it is. You might think that it's just how much they were making versus how much they're making now, and then that's your amount, and that is incorrect. The way that you do it is the average weekly earnings for temporary disability, the standard 52 weeks analysis, and then you subtract from that their current weekly earnings or wages earned while disabled, and then you get the wage loss amount. But then, because it's TD, you're going to multiply that by 2 and then divide by 3, which everyone should notice that's generally how average TD is calculated from the average weekly wage. And that's how you get the compensation rate for temporary disability. So to simplify that, it's going to be the difference between what they were making versus what they are making now after the injury. And then you're going to multiply that by 2/3. And you are going to get this in a handout. And once you actually do it, it's a lot easier than seeing it. At least for me, I am not a math brain. So the formula is scarier than the actual calculation. But I bring this up because I have seen wage loss calculated incorrectly before, and then it becomes a whole penalty interest issue to bring up. Also, sometimes applicants' attorneys don't know how to calculate wage loss, and so you don't want to just go off of how they're providing it to you. If it's a subsequent employer that you're using for wage loss calculations or self-employment, you want to make sure that the employee or applicant's attorney is providing you with their time cards so that you can make sure to calculate that out correctly. All right, but how do we get to wage loss if we don't know what average weekly wage is? So you do want to make sure that you're starting with the correct average weekly earnings. Earnings means the employee's gross, not net earnings. So you want the bigger number, not what it is after everything gets taken out. Most of the time, the applicant's earnings are calculated by determining the total amount the applicant earned in a year before the injury and divided by 52 weeks. But you do want to take into consideration other factors that may come into play. This could include lodging, meals, travels, etc. If any of this is covered by the employer, those might be brought into the average weekly earnings. If you want to see what exactly you need to consider, if you have one of these situations where maybe the applicant's being reimbursed for more than just their salary, Labor Code Section 4453 is where you want to go to get that information. Seasonal workers. I incorporated this into the presentation after I presented at CAAA, the California Applicants Attorneys Association's grand conference last June. And the reason why is that they were really harping on, one, making sure that average weekly wage is properly calculated so that they can maximize the temporary disability payments of their clients. And this became very heated when it came to the issue of seasonal workers, partially because there are so many different types of seasonal workers and they can all be compensated a little bit differently. So again, I did a whole presentation on this so we could really get into the weeds on it, but in general, this is what you should know if you have a seasonal workers case. The appeal court issued an en banc decision that seasonal workers should be awarded temporary disability indemnity at two rates. One, an in-season rate based on the employee's in-season earning capacity, and an off-season rate based on the employee's off-season earning capacity, taking into consideration such factors such as the employee earnings history, willing and ability to work, age and health, education and skill, as well as employment opportunities and general condition of the labor market. And that case we know as Jimenez versus San Joaquin Valley Labor, Superior National Insurance in 2002. So what is this trying to say? It's essentially saying that temporary disability payments should be based on any reasonably anticipated wage increases or decreases that the applicant would have received while temporarily disabled. Here's the example that they used, and it is an interesting one. A worker going to college to become a veterinarian assistant. So she gets injured from another job, but she's currently going to college. She could show what her earnings would have been if she could have finished her degree and started working. But now, for whatever reason, this injury caused her to be unable to finish college. For example, let's say it was a neurological injury, or since she was becoming a vet tech, potentially something in her upper body, etc. So now she can no longer become a veterinary assistant. This can be considered by a judge when determining the rate for average weekly wage and temporary disability. Fun fact, that's actually the case, facts of a case that came down where the WCAB determined that the applicant was not entitled to temporary disability because she hadn't shown enough good faith that she was going to go down this determination. This is an older case, however, and the panel, including a judge from the Oakland board, opined that should this same case come down today, she believes it would have come down differently. Now that we know how often people actually go into this career, etc. So again, even if the facts of the case seem pretty black and white, judges don't always agree on how to calculate indemnity payments. In Signature Fruit, a case that I'm sure everyone has at least heard of, the appeals board agreed that the applicant was entitled to receive temporary disability based on minimum rates during the off season, after the defendant sought reconsideration of the judge's opinion, the trial judge's opinion. In this case, the applicant was a seasonal sanitation worker who earned $548.38 during the season. She had no earnings or employment the rest of the year, and the season was only from July 29th to September 9th. The applicant sought medical treatment, and her doctors placed her on modified duties and told her to come back on September 8th. The employer couldn't accommodate her, so they paid her indemnity, temporary disability indemnity, through September 8th and laid her off on September 9th, which is when her season would have ended regardless of the injury. Applicant missed that September 8th follow-up and instead went to a chiropractor on October 6th, who stated that she was still temporarily disabled. The applicant argued that she should receive temporary disability at the minimum rate, despite Jimenez, which was the case that we just talked about, that requires you to show that you would be earning something in order to receive temporary disability during the off season, because on January 1st, 2003, the law had changed to establish a minimum temporary disability indemnity rate. So before January 1st, 2023, there wasn't a minimum rate. The WCJ, so the trial judge, agreed and awarded temporary disability based on the minimum rates during the off season. So which one is it? It's important to remember that this is a factual cases decided on a case-by-case basis. But the message in both of these cases, even though they seem to be opposing each other, is the same. The defendant's burden is to show that the employee would not have made more during that period. But the employee can show that he or she would have through concurrent employment, alternative employment, or proof that long-term earning capacity would have likely increased. So how would we be able to prove that the applicant wouldn't have made any more money? We offer modified work and it's rejected with no real support for it. We show a history that the applicant has never worked in the off season. You could potentially use their other skills if they have skills where they could maybe move into a different labor market, even with their restrictions, but they haven't. Again, it becomes quite the factual situation. You'd want a deposition to figure out the applicant's whole history, and maybe even start subpoenaing bank records, et cetera, if you think that there might be something else there. Also, investigative background checks, maybe some sub rosa to see if there is anything else going on. And how would you know if anything else is going on? One, if your spidey senses are just tingling because we've been at a desk long enough to where you know that something seems up, or there's just a lack of income coming from this individual and you know that they have a family to support, so something has to be happening somewhere. Those are all little things that's going to warrant maybe more investigation. From my experience at CAAA, I know what applicant's attorney is going to argue, and they're going to go way back to a 1990 case called Rubalcaba, where the Court of Appeal held that basing an applicant's disability compensation rate on the employee's actual earnings at the time of injury is unfair and unreasonable, where there is specific demonstrable evidence that the employee's long-term earning capacity would have likely increased. So in that sense, what would we do? Prove that there is no evidence that the employee's long-term earning capacity would have increased in the future. And this would likely come up in labor cases. And my one caveat there is don't set yourself up for a 100% case by saying that this applicant absolutely cannot come back to work because they have no other skills. A applicant's attorney who's paying attention might see that argument to try to terminate TD and then create it into a 100% case based on lack of ability to continue working. That gets us into a whole other situation, but just to make sure that you don't lose the forest through the trees on that argument. But depending on the situation, it may be worth going ahead and making that argument that they're not entitled to TD. If they're a minimum earner, maybe it's easier to just pay that out than create an issue about how the applicant absolutely cannot work anymore. In general, so what do you want to consider? Is there demonstrable evidence that the applicant was oriented towards a definitive future career goal? So like the example we talked about before, going to college while working part-time. How far into college were they? How well were they doing? Because if they weren't really doing well and they might not graduate, obviously that's not really demonstrable evidence that they were going to make more in the future. I would say that this is definitely something worth fighting when it's not an issue of minimum TD versus no TD, but if it's an issue of the applicant's attorney trying to significantly increase a applicant's earning capacity in order to increase their TD rate. That's, I think, where this battle really matters. Retirement and termination. I get this question, I would say almost monthly, and there's a lot of case law on this issue, but we're just going to try to summarize this so that everyone has a basis on it. And if you'd like the case law on it, please don't hesitate to reach out to me or Tom, or if you have a specific case you kind of just want to walk through, that's why we're here. To determine whether an employee is entitled to temporary disability following retirement, the employer must assess, 1, whether the employee is retired from all purposes or only from particular employment, and whether the decision to retire was related to the industrial injury. I should have put a little asterisk here because this is the rule for temporary disability, not the rule for the voucher. A lot of the times they seem to run hand in hand, but this is one situation where the requirements are different. A voucher is essentially owed unless a return to work offer was made, regardless of why it wasn't made, unless there was a termination for cause. Like, for example, they were arrested for stealing on the job and then they were terminated. It's a high bar for cause. That would also work to terminate temporary disability. But if an applicant's retired for whatever reason and no return to work offer was made, the voucher is owed. That is not the case for temporary disability. If the employee retired just because they were at age, they had reached their pension amount, it had nothing to do with their injury, you can terminate temporary disability for that reason. But if you have the employee saying, no, I actually was forced to retire because I couldn't return back to work because of this injury, then you're going to owe temporary disability. The burden is on the defendant to show that the applicant left the employer and that the employee truly did voluntarily remove himself or herself from the labor force. So this is, again, where we do presentations directly to employers to say, how do we properly document that? We definitely want it in writing. We want the name of any witnesses who had that communication. We want all the knowledge and statistics involved with what a voluntary retirement looks like for that employer, because it obviously differs, from a regular, just private employer to a school district to a safety officer. All of those have different rules and requirements going into it that can help us differentiate whether it was truly voluntary or industrial. All of that proof helps. The employee then obviously has the ability to try to prove that it was his or her intent to pursue work that was interrupted by the industrial injury. Hopefully that makes sense, but obviously we both just have the burden of proving what we're trying to show. So if we want to terminate TD, we want to be able to show that they left voluntarily. They're going to try to show that it was only due to this injury. And again, we need the written proof because at trial, the WCJ is going to give applicant the benefit of the doubt. So if all we have is the applicant's testimony, the judge is going to lean towards the applicant unless we have proof to show otherwise. And even though witnesses are great, at the end of the day, nothing can beat contemporaneous written material that is not just presented at the trial, but was contemporaneous to when that voluntary resignation was being considered. All right, so that's it for today. I'm not sure if anybody has any more questions. Tom, if you're talking, you're still muted.
No, it just takes a few seconds to get the, I don't know, the wheels turning on the camera. But I didn't see any other questions in the little pop-up window, but now's the time, folks, if you have any.
Well, I would like to thank Go ahead.
I was just gonna, and again, if you have any questions that come up later, please don't hesitate to reach out. That's why we're there. We're nerds. We love talking about this stuff. So just go ahead and reach out. Don't be shy.
It's sort of sad, but true.
No, it's excellent to have an attorney that loves what they're doing, right? Because you're passionate about it and you want those great results. So I just want to thank, and I want to thank all of you for being here today and joining us, and Wendy for hosting with me. And Wendy wasn't feeling so good last week, so I'm delighted that she was able to join us this week. And I hope that for the rest of the week, Wendy, that you are feeling better. All right, we do have more webinars coming your way. We have another one this afternoon, and that one is on the workers' comp fraud landscape. So if you'd like to join us for that, there's still time to register. We also have another one on Wednesday, and that's going to be the Guardians of the Apportionment Galaxy. So we are going to have something very fun to watch there, and that'll be on Wednesday. And then the following week, we will have yet another 3. And myself and James Rothsey are going to be closing out the 12 CEUs of Christmas. So we'd love for you to join us on that very last one on unlocking successful apportionment. So until the next webinar, I'd like to say thank you. I hope all of you get your holiday packing and cooking and baking done, and so that this year will be stress-free for you. Bye-bye, everybody.
Bye. Thank you guys for having us.
For joining us.
Thank you.